You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found ME Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose ME Support.
Hello, everyone, and welcome back to this very exciting and important webinar that is lined up just for you. Make sure to watch this session till the end, and also it would be lovely if you can participate in this webinar. And also don't forget to like, share, and subscribe to our channel. So before moving ahead, let me read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. All right, friends, with this very important disclaimer, once again, welcome back everyone to Immigration Talk Show, and it's me, your host, Sam. And talking about today's topic is again very important one and a very demanding one. US green cards through work. What are your options in 2025? So friends, in 2025, getting a US green card through your job can feel challenging because there are so many different categories, rules, and new updates as well. And it is very easy to get confused. But don't worry, because in this webinar, we are going to break it all down for you, from the fastest options to the lesser known ones. We will talk about the popular EB1, the flexible EB2 and IW, also EB3, 4, and 5. So stay tuned, and I'm sure by the end of this session, you will have a clear and a very simple roadmap to make your green card dream a reality. And you know what? To make this session a wonderful one, I have a guest who has an expertise in the employment-based visa category. None other than attorney Jessica Weiss, who's a top immigration attorney, also known for helping entrepreneurs, investors, and professional athletes with visas like the E2 and O1A. She is also awarded the 2019 Global Chamber Award for Immigration Legal Services. So it's been a long time, and Jessica is here. So really excited for this webinar. And hi, Jessica, once again, a very warm welcome to Immigration Talk Show. How are you doing today?
I'm doing great. Thank you so much for having me back. Thanks.
That's lovely. And friends, it's our honor to have a show with you, Jessica. And you can also go ahead, friends, just by clicking on this link. You can visit this link and you'll get the contact details of attorney Jessica Weiss in case if you're finding any complexities or any difficulty in your immigration journey. She would love to help you out. All right, so Jessica, do let us know more about you. You know, we have been meeting after a month, I guess. So how was your work going? How was everything?
Great question. Well, pretty much every day things are changing in my field. When TPS got canceled for certain individuals from different countries, that affected my field a lot. I'm getting a lot of calls from employers that are trying to work through to figure out ways for their workers to stay here longer or to switch to other categories, or they just want to know what their rights are. Are they complying with I-9? Do they have to do E-Verify again? There's a lot of, this could be a whole nother actually class on E-Verify, I-9, and what employers need to do now because they're nervous. They're getting watched by the government. So there's a lot of that. There's also the new, in April, Trump made mandatory registration for people that are in this country that are foreigners. So everybody has to have their papers in order. If they get stopped for a traffic violation, if they're traveling on a domestic flight, they have to show proof that they have a legal right to be here. So that's also made immigration lawyers tell their clients, like, you really have to have your papers in order. Like, you have to have your receipt notices when you travel, just have to have things in order. So it's definitely keeping us busy. It's been busy.
That's right. And it's us also, Jessica, because every day we have been coming up with so many different updates, new rules, new policies. So, friends, I think this time it is very important to stay informed and stay updated with all the latest news that's happening in the world of immigration. So, kindly go ahead and subscribe to our channel. Our handle is at Immigration Talk Show, and it is very important. So, I hope you won't regret it. Okay, all right. So, Jessica, I think without any further ado, we should directly jump into our questions. And I have so many questions for you. And our audiences are also waiting eagerly to ask those questions for you. So, let me go ahead with the very first one. That have there been any big changes in how USCIS is handling EB1 or EB2 NIW green card cases this year? Are approvals harder to get now, or is it becoming easier?
Wouldn't that be great if I said everything's moving along smoothly and everything's getting approved easier and very high percentages are getting approved? But the reality is it's not. So what's going on is the EB2 national interest waiver is getting harder to get approved. I have some statistics here. It looks like in 2024, the approval rate hovered around 43%, and it was down from, it was 80 to 96% in previous years. So it looks like the denial rates are getting higher. It's getting harder to get approved. Why is it getting harder to get approved? They're asking for a lot more detail. They want more specifics. They want to show how, for national interest waiver, the work that you're going to do is going to be a substantial national importance. That's important to show. They also want, they're saying now that, like, even though the position that you're going to be working for may have national importance, they want it to really, it's the actual position itself, not the job duties of a position, like, okay, those are important job duties, but they want the whole position to have national importance. And I know it sounds like a fine line to distinguish, but they're distinguishing it. So you have to show that what you're going to do is not just going to impact your job and your local community, it's going to impact the whole nation, the services you do. And so they're being much more critical of that. And that's causing, I think, some of the denials. So EB2, national interest waiver, was an easier path for a long time because you avoid the labor certification. But it's hard. It's getting harder. The EB1As, I love EB1As. National interest waivers are interesting too. Can be very interesting cases. But EB1As are people that are in the top of their fields, you know, the extraordinary, like, top 1% of their industry. And so how do you show that? So EB1A is a lot of documentation. It's a very high standard. It's always been a high standard. So I don't think there's been a huge change, maybe a little bit of them being more critical of the EB1As. I think that the EB2s, though, are really getting hit more with the changes in 2025 because they're much more critical of those. That's what I see. I mean, I have a statistic here. I think for EB1As, it was in 2023, 70.5% were getting approved. Now it's about 60.77%. So it's dropped a little bit, but I still think the EB1As, we usually don't take the EB1A cases unless we really evaluate it to determine, do you hit 3 of the criteria strongly? So we're doing a preliminary evaluation right at the beginning. And if we feel that way, then we're going to fight for them. And hopefully we get it approved. So that's the story with EB2s, EB1As.
All right, that's wonderfully explained, and thank you so much, Jessica, for taking up this question and explaining it beautifully. All right, so Jessica, as you have been saying that the process is becoming a little difficult and also scrutinies are happening. So recently we have gotten news where the F1 and the H1B, they have to go through a social media screening process. So nowadays their social media presence and their profile is being highly considered and very important. Are we seeing the similar process that may include an employment-based category, or what is the update for that?
So it's interesting. I heard it more with the F1s than the H1Bs, but it could be that you're hearing from people they're also getting scrutinized through social media. But F1 is because they are concerned. We need to understand their background before we let them come in as a student. So that's why they're doing the social media backgrounds. And they stop the F1 visas processing out of the country. They stop that because they don't feel their systems are in place exactly to examine the people coming in properly. So now they just suggested that we're going to look at social media. But in terms of anyone who's trying for any type of visa, the consulates have a right to scrutinize social media. They always have. They even have a right when you're entering this country. They could say, can you open up your phone? I'd like to take a look at it. Or your computer. I'd like to take a look at it. So I always tell people, like one of my clients said to me, well, I'm not such a huge fan of Trump, and I think I've put that on social media a little bit. I'm applying for citizenship. Do you think that's going to affect my case? And I said to them, that would be a very sad day if you don't have a right to your political opinion. If you're saying something dangerous that's going to harm the country, that's a different story. But just because you don't appreciate, value who's the president of the United States, that should not be a reason that you can't come in. So I think anything's fair game. They're just looking for any violence, anything that, they feel someone would harm the country, and anybody. They can look at anyone's social media if they wanted to.
That's right.
Yeah.
Yeah, absolutely. That's very well said. And I think it's not only about F1, H1B. I think everyone, who is trying to go ahead, live and work in the USA. So, friends, I hope just in the beginning of the session, you are getting a lot of insights from attorney Jessica Weiss. And Jessica, all the time, you are superb. You are a great communicator. So I'm sure our viewers are understanding each point of yours. And friends, the best part is, in case if you're having any problem or any trouble in your employment-based visa, then please go ahead and you can visit out this link and get in touch with attorney Jessica, and she would love to help you out. Okay, so with that, Jessica, let me go ahead with my next question.
Sure. Can I just add something also? That we're here as immigration lawyers to protect you. If there's a law, if there's a way to keep you here, we are going to try to do that. We cannot keep you here if you do something unlawful and there's no way to protect you. I've had clients call me up completely desperate to stay here, and I've tried. There's no way that I can help them, but I will try my best. If there is a way, we will try to help you. But if you've been here unlawfully for years and there's no regulations that are going to help you, we can't help you. So that's our goal, is to help you. That's the bottom line. We try to.
That's beautiful. Okay. So now I think let me go ahead with my next question. Jessica, it is that why are we now seeing green card delays, not just for India and China, because India and China have been one of the top most, I think, like top 5 numbers in terms of getting delayed and backlogs. But it's like people from other countries are also facing the same problem. So what's causing the shift, and what is happening? If you can just let us know about it.
Okay, so there's a lot of different factors here. Okay, first of all, America is still a very popular country to come to. So there are 140,000 employment-based green cards issued per year. Each country has a 7% allotment. So yes, like countries like China and India, where there's like tremendous, there's a lot of people wanting to come here, there's going to be backlog. But now we're seeing other countries as well, because a lot of people want to come here, and we have those limitations. But other factors as well, as we have system issues. There's some inefficiency at the consulate, at the National Visa Center. Some people go back and forth so many times trying to give documents over, and finally when they clear it and the case goes to the consulate needs to go to, then the consulates are backlogged now. Maybe they weren't backlogged, but now they're backlogged. Or their visa number, their priority date was current and now it's not current. So that creates a bit of a mess. Also, there's something called, just made a note here, it's called the Controlled Application Review and Resolution Program. And it's a secret, I don't know if you're familiar with it, a secret security system that the Immigration Services uses to check people's backgrounds. So if there's any delays in that process, that's also going to create, it's called CARP, C-A-R-R-P. And they use this to check people's backgrounds. And some people say they're using it from countries that they suspect more terrorists come from, that they're getting subjected to this more often than others. But it's out there, it's there. Also, more interviews. More interviews are happening. We had heard originally that everyone's going to be interviewed for employment-based green cards, including in the United States, not just at the consulates. But then I've had recently several clients that were not interviewed. And they were like, I'm surprised. I just got my green card in the mail. No interview. So it happens. But all of these factors are causing backlog. And in terms of solutions, well, we can say they need more staff. They need better systems, electronic systems, but it's not going to change the numbers. There's only a certain amount that they will issue of these green cards, employment-based green cards, per country, per year. And unless that changes, there's still so many people that want to come here, and it is backlogged. It's not a good system. No, another way to explain it, it's not a good system.
That's pretty sad, and I hope so that after some time we'll get a system more fairer and more transparent, and let's hope for the best. But okay, I think Jessica, you're not agreeing with the fact. Okay, no worries. So I think we do have a lot of questions, and friends, stay tuned, stay connected. And we will take away your questions, and those questions are also very interesting. Don't go anywhere. It's me, Sam, with my today very special guest, none other than attorney Jessica Weiss. We'll be joining in just a minute, so don't go anywhere. Keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found ME Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose ME Support.
All right, friends. So once again, welcome back, everyone, to Immigration Talk Show. It's me, your host, Sam, and today we are having a great discussion with none other than Attorney Jessica Weiss on the topic get a US green card through work, and what are your options in 2025. So till now, we have covered some of the basic information, and we will go deeper into the topic. So hi, Jessica, and shall we move ahead with more questions that I have for you?
Sure, this is fun. I wouldn't say fun, but it's informative. But I'm enjoying it.
Okay, all right, that's great. And let me go ahead with this one. So USCIS has stopped requiring COVID-19 vaccine proof for green card cases as of January 2025. So how does this change impact the current and the future applicants?
This is great. This is really great because I can tell you story after story of people that did not file their adjustment status cases because they refused to get the COVID vaccination. I can tell you stories of people that applied for the waivers, medical reasons. It was medical, ethical, and it was also religious reasons. And they went through. All of the waivers went through. I didn't have any problems getting them through. But now you don't need it. You don't need a waiver. You don't need COVID vaccination. They've changed the rules. They're actually making a new form that will reflect that as well, that you have to use. I think it's dated like January 20th, 2025. You have to use a new form as of January 3rd for the medical form for the medical exams. And it really, I think it's going to help a lot. The only issue is going to be is that if you filed a medical exam and your case was denied and you're going to refile an adjustment of status for some reason, you can't use that medical exam. You're going to have to get a new one. So that's a little bit of like for people, they're going to have to pay again, whatever. But overall, this is good news. This is very good news. So cases will be processing and they're not required these COVID vaccinations anymore. So
That's right.
we're happy.
That's absolutely correct. A big point of relief. Okay, and following January 2025 changes to H-1B rules also, because every day, Jessica, we have been seeing new updates and new rules on H-1B visa. So what are the implications for employers in terms of sponsorship and green card planning?
So I would say a couple of things. On January 17th, 2025, I just see my notes here, that immigration came out with some more information about H-1Bs and what they're looking for. So they got very specific with, they want two things. They want more detail in the job description to show that this is a specialized knowledge position. And they also want ability to pay the wages. They want to see clearly that the employer has the ability to pay the wages. Now, those two are just general requirements. Then you get into the nitty gritty. If you have a startup company, sometimes they don't have ability to pay right away. So we have to prove it through investors signing letters saying that we're investing in this company. There are other ways to prove value, that a business is going to have potential value. So that gets a little tricky with newer companies. But detail, we're going to look at some of the trickier categories like tech categories like computer software and other ones that we're like, are they going to come after these market research analysts? Like, we're going to really try to get a lot more job description. And what we do now is we take their transcript from their bachelor's degree and we show all the classes that they've taken and we show how that relates to the position they're going to be in. So we can tie those two in together. And when we do that, we make a very strong case for them. So we're doing that more. I would say also people know as well the registration fee when you try for H-1B lottery, it went from $10 to $250 per person. So that was a change that we saw too. And then also we just see the amount of people that applied for H-1B. Statistically, I have here that it was 470,342 last year. And this year was 343,981. 981. So you had less applicants applying. But in the end, anybody that got the H-1B, now they're thinking, okay, I have the H-1B, how am I going to go to green card? So the whole thing needs to be evaluated together, because if you have an H-1B, a lot of times they want to stay here and they want green card. So whatever you put in an H-1B application, it better be consistent when you go for the green card. And we talk about the whole picture to make sure that, because sometimes they want to use experience from the H-1B for their green card. And there's certain ways you can use that, but we have to set it up properly. So we have to be careful with that, because we don't want them coming back saying, we did a beautiful H-1B for you, but now my green card, I'm stuck. I can't put it together properly. So it's very important, the strategizing of everything. And again, we focus on if there's been any changes to the H-1B, if they've increased salary. Also, another thing that's out there is maintenance of status, because you have a lot of the F1s that go to H-1B. We have to make sure that they can slide nicely into it, that they got their OPT to cover them during that period when a lot of them end school in June. And then it's called cap gap, and then they keep working OPT until they can start their H-1B. So we have to also make sure that's covered properly so they can start their H-1B October 1st. So we look into a lot of different things, but those are just some of them that's going on.
All right. And
sorry. I was just another thing. The filing fees are very high now. So a lot of the employers are like, when they're writing that check, a lot of them are doing an expedite fee, which is $2,805. So when they write that check, it's almost $6,000, the filing fees, and employers have to pay it. So they really must want this worker. That's a lot of money for them to invest in a worker. So that's also another thing that's frustrating. And the E-Verify and the I-9 systems all have to kick in once the worker comes on board. So that all has to be also figured out. So there's a lot of factors. They really need proper advisement for H-1Bs. It's not something you can just say, I made the lottery and I'm just going to do it myself. It's not, H-1Bs don't work that way.
Absolutely. Yeah, and that's very well put up, Jessica. I'll say that thank you so much for, clearing up those factors. And we have been reading for the very first time in 2025, there are certain applicants, so there are some people where the H-1B demands are decreasing. So it is quite shocking and quite surprising, but it is happening, and maybe because of the factors and the reasons that you have mentioned. So let me go ahead with my next question, and this is again a quite interesting one, and regarding the gold card, that is a very hot topic right now. So what do you have to say, Jessica, that President Trump has floated a $5 million gold card, and he said that it can replace EB5 visa. So firstly, is this feasible, and how would it interact with current green card pathway? What's your thought on that?
I like how you put it, it's floating. Floating the idea. It's still floating, I think, because it's not out there yet. We don't have the regulations. What he did do, and if anybody wants it, you go to trumpcard.gov and you can click on it and you can register to get updates on when this card's going to come out and all the requirements, whatever, of the gold card. But the EB5 world, according to some of my peers that I've spoken to, says that it cannot happen without congressional approval. EB5 had to happen with congressional approval. So they're saying he can't just create a gold card directly without getting congressional approval. So will it happen or not? Will it take over the EB5? I don't know. I mean, they're claiming, what I see from my resources, almost 70,000 people click the trumpcard.gov. Now, I don't know if all of them are going for the gold card, but that's a lot of people. Yeah. So is it really that many? And when I talk to some of my clients in different countries, I say to them, I understand EB5, it's a smaller investment, $1,050,000. But I said, do people really have $5 million? And he said to me, yeah, they do. He goes, there are a lot of people. If that's a fast track to get to America, they do. So I don't know. I don't know what's going to happen. I think it's going to keep floating until he brings it down and creates the regulations. And then we see like what's going to happen, because it's interesting. It could really produce a lot of income for this country. If that many people are interested in it, it could be very interesting when it happens.
Absolutely. I do agree. It is a very interesting topic, and let's see what happens, because if people have that much amount, then that's great, because that can also be the fastest way. Okay, and let me go ahead with my next question, and this is regarding cross-chargeability. So how does cross-chargeability work in 2025, and also how can couples use it to move faster in the green card line?
Okay, so cross-chargeability is two people are going to file for a green card. So we look at where were they born. It's not where they're a citizen, it's where they were born. And if one person, let's say, is from India and one person is from Canada, let's say. Well, Canada doesn't have a backlog in certain categories. So if we go to EB1, for example, cross-chargeability, and we see that the husband is the Indian citizen and the wife is Canadian. So we note on the I-140 their places of birth. It's on the forms. And then we put it on the cover letter. We say, please note, this is cross-chargeability, that we want the employment-based visa numbers to go towards Canada for this family, not towards India. So that bumps them up. So then they can do it faster, the whole application. And you can do it if you're doing adjustment of status in the US, or they're outside the US and they're going to do consulate processing. But that's what it does. And it really helps if people are aware of that. So if anyone's from India out there listening to this, or China, if you're married to someone from a country that's not backlogged in our system, it's a great way to come here faster.
That's right.
Yeah.
A pretty way. But I think there might be some, what do we say, eligibilities or some criterias. I think if somebody is from Portugal or if somebody is from India, that Portugal also has to come some under category, right? Or how is it? If you can explain it in a little detailed way, then that would be easy.
Every country, like if you go to the visa bulletin, there are certain countries that are backlogged. So those ones we see very backlogged. But then, of course, each country has to be checked to see if they met their 7%. But they usually don't, unless there's some mad rush from particular countries. But sure, you have to check with each country and see. I know, because I work with a lot of Canadians, that they haven't reached it. So it works very well. But yeah, you definitely have to check each country.
Okay, that's interesting. And that's a very smart way, I'll say, to get a green card. All right. And another very important and a very demanding question, Jessica, that I have for you, that how do you counsel individuals who ask that what happens if I lose my H-1B job during green card processing? Also, can I sponsor family members once I have an employment-based green card?
Okay, so let's take each part of the question. So what happens if I lose my H-1B job during the green card process? So where are they in this process? So let's say they have an H-1B. Now, H-1B, as many of you may know, that you have a 60-day grace period. So you can go find another employer and file another H-1B. You're not subject to the cap, and you can get another H-1B. So that's one thing. We want to put you in H-1B properly. Okay, then the question is, where are you in the green card process? So is the I-140 approved? Is the I-140 still pending? So we need that I-140 approved, and the I-45 should be pending for 180 days. So if that has not taken place, then it's a bit messy, and I'm just going with a cleaner answer right now. So if that's taken place, then you can port to another employer. So you can, and it's not just the job title, it's the job duties need to be similar. So not all is lost if you are getting, your first job is ending. But the question is how to bring the family along. So it depends where they are in the process. Everyone should be listed on the I-140. When you file the I-140, that's the first part. Well, there's 3 parts to the green card process: labor certification, I-140, and then the I-45 or consulate processing. So the I-140 part, all family members are listed. If they're listed on there, then they just come along with the green card process and continue it as you continue it if you've ported to another employer. If they haven't been listed on there, then we need to understand, why were they not listed? Did you just get married? Did you just have a baby? We need to understand what's going on, and then you have to update the file. So you may have to do an amended I-140, add the family members in. So it just depends where you are in the process. But as you can see, this is complicated. And this is AC-21 was a rule that came about in 2000, I think. And this is trying to protect you. So if this happens, they created it because not every employer is going to stay on board for 5 years or however long. If you're from China, India, these countries, they have to stay on board for 10 years. I mean, it could be a long time they're on board. So you might not want to keep you as an employee. So this is why AC-21 came about, to help them. And the other thing is with H-1B, as you probably know, that you have a 6-year limit. That's it. So if your labor cert's pending for a year, or the I-140 has been pending for a year, if that's taken place, then you're going to get extensions of your H-1B. 1 year, 2 years, sometimes 3 years. And I've been in those situations with people from especially China, where I was with them the whole process until their priority date was current. And then we were able to adjust all their statuses, and they kept renewing their H-1B. And we have to keep explaining to immigration, because we're like, they're on the 10th year of their H-1B. And usually they see once it's 6 years, no more, but you could keep getting it for years. So you could be in a very good position as long as you have good legal advice, so you don't miss any of your deadlines. That's the answer. It's complicated.
It is, and actually very complicated and challenging. But you have explained us in a great way, and I'm sure our viewers are noting all the points down. So, friends, in case if you're having any doubt or any follow-up question or any query regarding the topic, then please go ahead and feel free to put them on the comment section. We are here for another half an hour and will surely take up your questions. And friends, the best part is you can also reach out to attorney Jessica Weiss. Just have to visit this link and get her contact details. Okay, and with that, Jessica, it is time for a short and a small break. So, Kritika, Ricky, and so many viewers, Karthik, thank you guys for joining us. Don't go anywhere. We'll be coming back just after a short break. So, keep watching Immigration Talk Show, and we'll be right back.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
All right, friends. So, welcome back once again to this very exciting webinar that we are having, and I'm sure you're enjoying it too. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. Also, we are not just here on YouTube, but also available on LinkedIn, Facebook, X, and on Instagram as well. So go ahead, and if you haven't followed us, then do it right now. Okay, and with that, Jessica, I think we have covered a lot in this webinar, and let me go ahead with some of our viewers' questions. So Karthik is here, and hi Karthik, thank you so much for your participation. He's asking what are the potential risks and consequences of transferring the underlying basis of my Form I-485 to a different employment-based immigration category? Yeah.
So different employment-based immigration category. So I would need to know probably which category he was thinking of, which category he was in, because usually you can't just, if you're in the I-45 part of the process, you can't just jump to a different category. If you're let's say EB3 or EB2 and you're dumping to a different employer, that's one thing. But jumping to a different category could create a problem. You may have to just redo it. Yeah, it doesn't work that way.
All
Yeah.
right, and that's right. And Karthik, do let us know, which category you're looking for, and if you're going to specify, then it will be easier for Jessica to answer. Okay, let me go ahead with Ricky's question. So, hi, Ricky, and once again, thank you so much for being here. Ricky is asking, can you give some idea on the typical processing time that you are seeing for NIW I-140 petition and the standard processing?
Okay, so the first part is filing with the Immigration Service, your application. So that I'm seeing right now processing times between 13 and 17 months, but that's if you don't expedite. If you expedite, you get an answer in 45 calendar days, but you're going to pay $2,805. So that's just the first part. Now the question is, when can you do the next part? So I don't have it memorized, but it's based on, it's the visa bulletin, and we look at the categories. So even, I could pull it up and you could pull it up really quickly. Just says, you just go to Visa Bulletin, just type it in as a search, and then pulling it up. I think there's a backlog of maybe 2 years, but I'm just double checking. And then there's two different charts on here on the Visa Bulletin. When you go to Visa Bulletin Department of State, and you have to know which chart to use, and they refer you to the immigration website. Yeah, I think it's about a 2-year backlog. That's what I'm seeing. Yeah, except for, again, countries like China, India, Mexico, and the Philippines, they have even longer backlogs usually. So once you get through that first part, you still have another 2 years to wait till your priority date's current. So total time, well, if you're not expediting, it could be 2 years, another 1.5 years, could be 3.5 years. Yeah.
All right. Thank you, Jessica, for taking up this. And let me go ahead with another question that we have from Ricky. Okay, so Ricky has a lot of questions, so don't go anywhere, Ricky. Stay tuned. We are going to take all the questions. So Ricky has that also, can premium processing increase chances of RFE for pending NIW I-140 petitions? If so, then how much will the chances of RFE increase?
It's interesting. When we do premium processing cases, we really want them to be green light approved. So we are doing everything to prevent a request for evidence, an RFE. So statistically, I don't have statistics on this, but I know that if you're doing premium processing, it doesn't hurt your chances of it getting approved. I think it just, you're usually being a lot more thorough because we want our client's case to be approved the first time. So I almost think maybe it could help it a little because we're being very careful with we're always careful with every case, but premium processing, because they're paying that extra money, we want to really try to get it round one approved. But of course, if we don't, then we just go after everything. Every little thing they say on the request for evidence, we respond to everything, and we fight for our clients. So that's the best I can tell you on that one.
All right, and that's very well said. Okay, Ricky has another question, Jessica, that if NIW I-140 petition filed by the employer is pending, can one still self-file another NIW I-140 petition separately? If yes, then what things should be taken care of for the parallel filing? Yeah.
Okay, so I assume that it's the same paperwork. The national interest waiver, it's the same thing, but you decided to file two cases because you can file more than one case, but they might wonder if they see them filed at the same time. So you have an employer, but now you don't have an employer. So I'm almost thinking maybe you should try one first and then file the next one, because it does look a little strange that you claim you're self-employed, but well, let's go back a second. For a national interest waiver, you have to show you're working in your field. So you're going to have a letter in there, right? Unless you're doing your own company. So self-file is not the same as like you own your own company. So it could be that this may be redundant because you still have to show you're working for them. So I'm not sure I'm thinking just file one. I'm not thinking you need two, because why would you need two? You want two shots at it, but it's still the same heart of the case. The NIW, national interest waiver part, all the documentation is going to be viewed twice. I don't think it's worth it. I think it's better to just file one. Why do people do self versus employer? Because they may want to work for other jobs, right? They don't want to be locked into that employer. But that's something that we'd have to discuss and see what is the strength of it. What would be, maybe there's other reasons I'm not aware of why you'd want to try for two. But I'm thinking it could be conflicting to them. They're not going to understand, why did you do two?
All right, no worries. Okay, let me go ahead with Kritika's comment. And hi, Kritika, thank you so much for your participation. So Kritika is asking that this question is on behalf of Dennis. I am currently on H-1B visa, and soon my sponsoring company would be applying for I-140 application. So I currently have credit card debts of around 23.5K due to layoff situation I had faced earlier around 2023. So could anyone please let me know if my current debt could affect my green card application? Yes.
So on the green card application, the I-45, they can ask you, what is your household assets, liabilities, income, those kind of things. And if they see there's very large debt, they can be concerned about that. They have a right to be concerned because they want to make sure you're here, you're stable, you're not a tax on our system or whatever. So you're not going to have, if they're getting ready to file the green card, you're going to have some time before you're going to have to go to this interview, if you have an interview. So I would say bring it down as much as you can, the credit card debt. I know it's not easy to bring it down, but I would try to bring it down as much as you can. And if they see you're making a good amount of income, but you do have credit card debt, that's explainable. You're keep working on it, bringing it down, and that shows you're going in the right direction. So I think it's still viable. Go for a green card.
All right. Thank you so much, Jessica, also for explaining things in a great way, and Kritika also for participating. And Kritika, I hope you have subscribed to our channel. If you haven't, then please do it right now. All right. So these were the questions that I wanted to take up from our viewers. And coming back to my own question, Jessica, if we talk about AI, AI is like everywhere from good morning to good night. We are covered with AI. And USCIS is also enhancing their work, their job by using different technologies, and AI is helping process application. So, should people change how they organize or explain their evidence? What do you have to say on this?
Well, I have to say that if you're going to write very long, lengthy cover letters, supporting letters, those kind of things, I don't think it's going to work so well with AI because AI has a system and they're looking for certain things. So I would make things more concise and then they can handle it better. I would have headings, I would have more standardized wording, formatting. I think concise explanations will be better. So I think it would help to really make it more concise if they're using, since they're using AI, you know.
Yeah.
And I think that's what I would say on that. Mhm.
Okay. All right. That's great. And moving ahead with my next question, Jessica, that if someone from India has been waiting for a green card for 10 plus years, so is it worth looking at other countries instead? Because US is having very challenging immigration policies right now. So people
You know,
are looking.
if you hadn't said India, I would
Yeah.
have said, 10 years is a long time, but that makes sense because it's India or China or Philippines or Mexico, but it's very difficult. We try to talk to them about maybe there's other ways. We say, do you have a family member? Are you married to a US citizen? Obviously, that's the first way we try. But in the end, if this is their only way, EB2 or EB3 is their only way to get here, and there's tremendous backlog, the question is, are they here on H-1B? Then they can keep renewing it year after year. If they're not, then yeah, we might say to them, our system isn't so hot. You want to get on with your life. There could be other countries, maybe like Canada has something called the express entry. And I think it's about 2 years. I'm not an expert on Canadian immigration law, but I think it's a 2-year process to obtain a green card through them, through an employment-based skills professional system. But sometimes there are clients that go to Canada first and they just wait until their number's called and they can come into the US. So they do need a long-term strategy. It is very difficult because it's so long. And don't even talk about brothers and sisters trying to come here from certain countries. That's like 15 years. I think Mexico or something, it's very long. So people have to plan their lives. And a lot of these categories, the EB categories, employment-based categories, have retrogressed. So when you thought it was going to be a year, it's now like 3-year wait. And certain categories don't have like H-1B. You can extend it after 6 years based on meet certain requirements. Some of their categories don't have that. So they're stuck. A lot of clients will leave if they have a category and they can't last here as long. And they'll come back hopefully one day if they still really want the immigrant visa. Yeah, it's not a good system. Yes, this is a flaw of it.
It does, and that's very well said that people are looking for other options too. And if we are going to see the same scrutiny and same, then of course, people earlier they don't even have to think about the other countries, but now the question are being arising: Are you looking for some other country or not? So a lot of changes and a lot of different things we have been seeing in 2025, and I think it's pretty eye-opening. And having these sessions with great attorney, I think it is one of the blissful thing that we have in 2025. So friends, if you are navigating any problem or any certain difficulties in your immigration journey, then I'll suggest that getting in touch with the expert and have a right guidance is one of the best solution. Go ahead, visit this link, and also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. All right, Jessica, we do have few more questions, and that is, are there any real chances that US immigration laws will change soon to reduce wait times, like removing country caps or using old unused green cards?
I wish I could give you good news on this one, but I can't make it up. It really is not going well. I mean, we
Yeah.
have so many, there's no laws in place right now to speed things up. I think India maybe is going to move up a month, maybe in some employment based categories for the year, but that's movement. That's all the movement we're seeing. It No, there's really nothing right now and we just hope it won't get worse. That's the thing. We don't want it to get worse. It's one thing we talk about that it's going to get better, but it can also get worse too. Like as more and more people want these categories, then it can create more backlog. If our system, we have a lot of things going now towards deportation matters. And even, as you know, some of these business visa cases, there's an asylum processing fee of $300 or $600, depending on the size of the company. 25 workers or more pay the higher fee. And so a lot of money and services are going towards the deportation right now. I'm hearing there's almost 1 million people that have self-deported, but there's a lot more. And this government right now, that is their focus. So this system is not their focus right now. I know you mentioned something about, I think we had talked before about raise, that it was a proposal or something a while ago that Congress had thought maybe this is a quicker way of somehow make things go faster to bring qualified candidates in for green cards. But that has not been talked about for years. So that was a proposal to move things along, but we don't hear a lot. We just don't hear a lot. So sorry, I don't have better news.
That's a pretty sad one. But I think that's okay. I mean, we can't do anything with it right now. But I think, Jessica, it's almost time, and we do have to come up after a short break. So don't go anywhere, friends. We'll be right back on Immigration Talk Show. Till now, we have covered a lot of questions from our viewers also and from my side. And now it's time to take up some Facebook questions because we have joined a lot of viewers on Facebook group as well. So just stay connected, stay tuned, and buckle up because I'm sure after the end of this webinar, you'll get a clear picture, a clear roadmap of which visa is going to be best for you. So don't go anywhere. We'll be right back. You just keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome back to Immigration Talk Show. And today we are having a great discussion with attorney Jessica Weiss on the topic U.S. green cards through work. What are your options in 2025? So till now, we have covered a lot and we are into a great conversation. So Jessica, I think with your permission, can we go ahead with some Facebook questions as well?
Let's try it.
Okay, let's go ahead. For control, please share the screen. All right, so Sunil is here. And hi, Sunil. Thank you so much for your question. He's asking a quick question that is it compulsory to hire an attorney or a professional to build my case for EB1? Yes, Jessica, what do you have to say?
I like the word compulsory in there. Nothing's compulsory. It's not required, obviously, but I can tell you in my 27 years of practicing, I've never seen anyone put together an EB1 that was strong enough for success. I've seen people put together EB1s, but I always have to go at it and take it apart and fix it up. It just isn't strong enough. It has to be, it's a very high standard. So someone with a great deal of skill that's been doing these for years can really take it apart and put it together, back together the way they like it. But even for a reference letter, it has to be written a certain way. They're looking for keywords. If it's too narrow that you made an impact in your local community, for example, that doesn't work for an EB1. They're looking for national or international accomplishments and impact. So I really do think an attorney needs to be involved. If clients are trying to save money to do some of it themselves, then they can try starting to put together themselves, but an attorney usually has to finish it. It's not enough to just do it on your own. I've never seen it. If it works, great, but I've never seen it work yet. Mm-hmm. So that's the story. Yeah.
Okay, and that's very well put up and very insightful because Jessica, in 2025, we have been seeing so many things and, it's better not to take a risk. So Sunil, I think I'll just suggest you can go ahead and reach out to attorney Jessica Weiss, and she is an expert in handling all these cases. And
I love
go
ahead. Great cases. They're so interesting, the amazing things that people do and really reach the top of their career. I mean, I could tell you stories and stories of some very famous, I work with lots of athletes as well, some famous athletes I've helped, famous entrepreneurs. Like really, they're very, and sometimes they're humble and they're like, what? I'm extraordinary. I said, if immigration says you're extraordinary, then you are, because they're humble. They're like, I'm really behind the scenes kind of guy or whatever. I'm like, no, you got an EB1A, you're extraordinary. So they're fun. I really enjoy them.
Wow, that's a great point, Jessica, that you mentioned. People don't even realize that they have extraordinary ability, and by having a consultation with attorney, they are realizing after that. So I think that's great, and that's very beautiful too. So I hope, Sunil, you don't do this mistake. Do let your know. Please let your know about your skills and abilities, what you have. I think getting in touch with Jessica will be the best thing.
And
Okay.
can I share one more thing
Yeah.
also? Sometimes
Uh-huh.
people are so experienced and knowledgeable in their particular field, they don't believe that it's extraordinary level. Like I had a gentleman that like he made a very particular type of food and it was so rare in his industry and he really had reached the top of it. And I'm like, it could be anything. We get creative. If you really think you've hit the top of your field and you meet those criteria, the 3 criteria of the list we give you, you could try. Anyone could try. But, what cases we actually take are the ones that we say, you know what, this looks great. Let's do it. So.
Okay, all right. Thank you so much, Jessica, for putting up these great insights. And let's move ahead with our next question. And this is Rizky. So, hi, Rizky. And Rizky is asking that, hi, I had an approval of EB2 and IW. I'm currently waiting for IVP. Somewhere I read that I need to submit police clearance certificate if I stay a country more than 6 months. I'm a British citizen, originally from Bangladesh, studied my undergraduate from India between 1996 to 1999. I wonder whether I need to get a police clearance certificate from India, as it's more than 25 years ago I stayed there. Any answer? Yeah.
I don't know how old this person is, but anywhere you've lived from the age of 16 and on, you need a police clearance certificate. So hopefully that answers his question. Anywhere. So, even if it was 25 years ago, if it was, 5 years ago, they want to see it. So he's going to need it if, 16 and up, wherever he was.
All right. Okay. Thank you so much, Jessica, for answering this question. And I hope, Rizky, you got your answer. Okay, let's move ahead with our next. And this we got from anonymous participant who's asking that anyone know how long does it take to be able to check status? If I filed E2 a couple of days ago, when I try to check status to see if it was received, the search does not return any results. Yes, Jessica.
So I assume that I'm thinking from the question that they filed a change of status in the United States to E2. Is that what they're saying? And they don't see where to check the receipt notice. That's what it seems like. So is that right? Is that what you're thinking? Okay, so then receipt notices are taking a long time. If you file premium processing expedite, you'll get it obviously faster. But otherwise, it can take a few weeks to get a receipt notice. There's nowhere to check it online, except here are some ways you can do it. So first of all, there's a form called the G1145. You can put this form in when you file your case, and you write your email and your cell phone. So when they get your case, they send you a text, we received your case. And your case number can be on there. So that's one way to do it. There's a form that you should have submitted when you filed your case. Another way is if you submit checks. If you're paying by check, then on the back of the check, when it's cashed, you could see your case number and proof that they received your case because they give you the case number. They cashed the check, you get the case number. So with the official receipts, and the thing is, it's interesting because now, because of the rules since April of registration, if you needed to do a change of status, which would give you a right to stay here longer, you need some kind of proof that you're allowed to be here legally. So I always tell my clients, if you don't have the receipt notices, if you have the text, you can go online and pull the case number online at the USCIS website. There's a thing that says check the case status, which they did. And if you have your case number, you put it in and print that out if you don't have your official receipt notice. So there's several ways to do this if you don't have an actual receipt notice. But if you're in a situation where technically your status looks like you're out of status, but you filed your change of status timely, then I tell my clients to really probably wait for the receipt notice before you start traveling domestically. You're going to drive around, whatever, in your car, but you should bring whatever you can to show proof that you filed timely. Track it, that they received it, the check or the G1145, get the case number. You should try to get something. But you're right. You're not going to get a receipt notice or anything like within a couple days usually. Regular processing in E2, change of status, you won't get that right away. It takes time. Yeah, it's frustrating. That's our system. I feel like I say that a few times. That's our system. That's what we have.
It's like full time you have been saying that, but
I
of
know,
course,
right? This is it. It's not great. It's our system. We try to help our clients. We want them all to have proof that they have a legal right to stay here. If they do, and that's what we try. So those are some ways we can help. Yeah,
that's right. And with that, I think we can just help you guys out. Okay, and let me go ahead with my next question. E2 visa holder can apply EB3 process. Is this create issue at a time of E2 renewal?
Okay, so I do a lot of E2 visas. It's one of my favorite categories, and I'm a national mentor on it. I educate young lawyers that are getting into the E2 visa field. The answer to the first question is E2 visa holders can apply for EB3 process, yes. And now the question is the timing. So we have to time it. We don't like them needing an E2 visa renewal. If they need an E2 extension of status as well, we'd like to time it. So this is how it works. So we have E2, if they get, let's say, a 5-year visa. Every time they come into the country, they get 2 years to stay here. So then we say, where are we in the process? So as you know, EB3, you have to do labor cert first. That could be like a year, year and a half. So during that whole process, we can take care of all that. It's all through the Department of Labor, and they can renew their E2 visas and all that stuff during that time period. Now, when we do the next part, I-140, that's with immigration. That's where I say, let's figure out where you're at. If we need to renew an E2, let's do it before we do the I-140. Once we do the I-140 and we do the adjustment of status or consulate processing, I don't like them to be involved with an E2 renewal. So we have to time it right. If they're in a situation where they do need an E2 renewal, we always set up the I-140 where we check off consulate processing and not adjustment of status. So they are saying to the officer, if they have to go get an E2 visa, that, look, I'm going to finish my green card out of the country. I don't have full intent to immigrate because I'm not saying I'm staying here forever and doing my adjustment of status. So these are little tricks of the trade that we do so we can set them up properly. So, and I've done this so many times where we take E2 to EB3 and they get green cards, but you have to time it right. It's very important, the timing.
Absolutely. Timing is very important, and that's very well said. All right. So I think that's all. And we have covered all the Facebook questions. And Jessica, I have to tell you that you were absolutely fantastic. All the questions you have taken. And it's almost the end of the session. So I think before leaving, any message or any last tips or strategies that you would like to give to the employment-based visa applicants, then please go ahead.
Sure. So I would tell the applicants that you still have opportunity here. There are great ways to come to this country. It doesn't matter who the president is. You could see in the media, whatever. I've had so many different presidents when I'm doing this, and there's still tons of people that want to come here, but you have to do it right. And I know there are many people are desperate to come here, desperate to do their cases quick and this and that. You got to patience is key, and you have to use competent people. I speak to everyone free briefly just to give them a little bit of direction. A lot of immigration lawyers do not do that, but I feel as a foreigner, they don't know anything. They need a little direction. If they like my style, they like my service, then they'll retain me, whatever. But it's my way of giving back a little bit because I know it's very hard. They don't know our system. So I tell applicants, I have a website. I have really helpful charts on it of all different types of categories. Read it over, read my articles on my website. And if I can help them, I'm happy to help them. But there are great opportunities to come here, but the paperwork has to be in order. So that's what I would say. Don't give up. I mean, even the people in India, 10 years, whatever the wait is, sometimes they go to other countries. Sometimes they, continue their lives where they live, and they have an opportunity eventually when their number's called, so to speak. They still have an opportunity to come here. And that's what we do. As immigration lawyers, we try to help them have opportunities. And it's not just for one person. It can be a spouse, children. It can be the whole family now will have an opportunity to come here. So I'm happy to help them. I love what I do.
And we are happy to have these sessions with you, Jessica. You are absolutely, brilliant, energetic. And we love having these conversations with you. And also our viewers have enjoyed this session a lot. So thank you so much. Let me greet to our viewers also. Kritika, Ricky, and Karthik. Okay, thank you guys for being here. And in case you are having any doubt or any query regarding the topic, then even after the live stream ends, you can still put up those questions on the comment section. Me with my team will get back to you and will provide the answer. And with that, Jessica, thank you so much. It was our honor to have you in our show. So thank you so much for being here and have a great day.
Thank you so much.
Thank you, Jessica. All right, friends. So that's all for today's this very wonderful and very insightful session. I hope you understood what are the different options in 2025 if you're looking to get a US green card through work. So it is a pretty challenging time, but as Attorney Jessica Weiss has said, that patience is key. Keep believing in yourself, and just keep yourself motivated and informed. And don't forget to like, share, and subscribe to our channel. Our handle is @Immigration Talk Show. So thank you so much, guys, for joining us. And it's time to sign off. So go ahead and check out our channel. We are not just here on YouTube, also on LinkedIn, Facebook, X, and on Instagram as well. Thank you so much for being here. See you next time. Till then, keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.